why you are here.
Okay. I'm Norm Townsend. I'm an attorney practicing in Washington, D.C. and Alexandria, Virginia. A friend of most of the defendants, having represented all of them at one time or another when they engaged in civil disobedience at the Pentagon, which is very near my office. I was asked to come up and help as I could in this case. I'm an advisory counsel, as they have no counsel of record. They're all proceeding pro se in this case. So our function is limited to that as of advisory counsel. Today, they're continuing the jury selection process that was begun basically on Monday, although Monday afternoon the jury that had been called that day had to be excused because of an outburst of the judge yelling at Dean Hammer, one of the defendants, about Dean's right to represent himself, indicating that the judge didn't believe that that was a wise idea. And his manner of doing that infected the jury, and he had to release them all. So he started all over again yesterday with jury selection. And he was permitting the defendants to do it themselves at that point. But because it was proceeding too slowly for his tastes, having previously indicated to us on Monday that he wanted this case to be over with by Friday, he's taken over the jury selection process himself today and won't permit the defendants to participate, although he will permit them to submit written questions. He won't engage in any extensive dialogue with the potential jurors that might reveal any deep prejudices or biases against the defendants or for the government. So in that sense, the jury selection process has really been aborted and is not functioning in the way that it should in a trial of this sort. And I think that's especially significant in light of the fact that of the first group of 40 jurors that were called into the courtroom, 2/3, perhaps even 3/4, indicated that they had formed a preconceived notion about the defendant's guilt. And immediately after that, the judge said, well, I direct you that it's your obligation as jurors to put aside those preconceived notions, to ignore those preconceived notions, and to decide the guilt or innocence on the evidence that you hear in the case. And he said, now are there any of you who will not do that, who will not set aside their preconceived notions? And 11 people said that they would not. And that's a full quarter of the panel said that they would not set aside their preconceived notions about the defendant's guilt. And you can be sure that if there were a quarter who were bold enough to say that there's at least another equal number who were too timid to say that. It's group dynamics being what they are. So I think that clearly shows that there is a great deal of prejudice against the defendants in their position in the county, which might be true regardless of where this was, but be that as it may, it's incumbent upon the court then to permit the defendants to pursue any prejudices that might exist and to talk to the potential jurors to find out what opinions they hold in order to get as fair a jury as possible. The way the court is doing that is saying, do you have a preconceived notion? If they say yes, then he says, well, you have to set that aside. And the fact that somebody has a preconceived notion at this point means that they've held that opinion for a period of 5 months. And it's virtually impossible for somebody to set aside an opinion that they've held for 5 months just because somebody tells them to do it. And that's why the defendants felt that it was vitally important for them to be able to engage in a limited amount of dialogue with the potential jurors to determine what their prejudices may be.
What's your personal connection to what's happening here, and why are you involved at all?
Well, I was asked to be. I was asked to be by the defendants who I said, as I've indicated previously, that I've represented a number of times in the courts at Washington and the federal courts in Alexandria, Virginia. As to why I wanted to do it, they're my friends and I agree with them. I believe that nuclear weapons are a violation of international law. In fact, after World War II, the Japanese war crimes, the Tokyo war crimes trials, a court of law determined that dropping the bomb on Hiroshima and Nagasaki was in violation of international law. Moreover, there are a number of international law treaties and other principles and norms of international law which can, in some instances, specifically say that weapons of mass destruction are a violation of international law, and that possession of and planning for the use of weapons of mass destruction are violations of international law and are against humanity, crimes against humanity. And that for that reason, this country's possession, and especially in light of the avowed policy now of a first strike capability, we are planning an aggressive war. We are planning for the use of weapons of indiscriminate and mass destruction. And inasmuch as those are violations of international law, I can't personally abide by the possession and use of those weapons, or planned use.
Do you have any hope for the outcome of this particular trial?
I have a great deal of hope for the outcome of the trial, but not in terms of whether these defendants will be found innocent. I think there's every likelihood in the world that they will not be, that they will be convicted and possibly sentenced to a great deal of jail time. The hope I do have for the outcome of this trial is that the attention that's been given to this trial and the attention that it's received in this county and elsewhere across the nation will cause people to stop and reflect a little bit about our role, our nation's role in planning for war of aggression and the use of nuclear weapons. I don't have any false beliefs that because of this trial, Ronald Reagan is going to direct the Pentagon to dump all the nuclear weapons. I don't believe that that's going to happen. But I think it will cause people to stop and reflect on it a little bit. And if we can at least do that, then we're a step in the right direction. And I believe that's possible because there are a number of people that I've met since being up here, since coming up here for the trial, from the Norristown area, Montgomery County area, who have used this to cause themselves to reflect and who have become involved in what's happening here, who have offered their hospitality and their services. And for that reason, I think that there is a chance of reaching people and making some understand. Obviously not everybody, though, unfortunately.
One of the perceptions I've had is that on this, on the side of the defendants, there doesn't seem to be any really clear-cut organization to follow up the action that they initially took, except for their basic defense. I mean, there doesn't seem to be any sense of, okay, we took one action, now another group of people will take another action built on that previous action. There doesn't seem to be any strong organization.
Well, there isn't right now. There is talk right now of attempting to continue the Plowshares 8 Support Committee as an ongoing entity to attempt to keep the spirit of this action going and to support others across the nation who either are going to engage in civil disobedience as a method of bringing attention to the issues, or for whatever other purposes that they might find to, or for what other methods of trying to get attention to the issue or address the issues. There is a hope that the Plowshares 8 Support Committee will then be an ongoing thing that can provide support to other groups and other individuals around the country who can keep the spirit of this action alive and the purpose for this action and the sacrifices that these particular defendants have made and keep that spirit going as an ongoing thing, supporting other people and groups around the same issue. That's the hope. I'm confident that will happen, but of course that remains to be seen. We're very hopeful that the spirit will not die, and that the support that this has brought about in this area and from people around the country will continue, and that they will travel around the country and keep pushing at this issue, and keep pushing it in front of people and forcing them to look at it and address the issues.
I was not aware that the dropping of the bombs on Hiroshima and Nagasaki had been declared a war crime. Can you speak more about that? Where did that happen?
Well, if I recall, the name of the case is a Shimoda, Shimoda, if I recall. But at the end of World War II, in Japan, they had war crimes trials similar to that held in Nuremberg. And there were two cases. They were not addressing directly the question of the dropping of the bomb. It was more dealing with the Japanese Commission of War Crimes. But in deciding the case, the court said, in an offhand manner, and in legal terms what's called dicta, that the dropping of the bombs, mass destruction on Nagasaki and Hiroshima were violations of international law, international norms.
Or Japanese court?
It was a military tribunal in Japan.
U.S. military?
Yes. It has, of course, no binding effect on the United States, particularly because they were dealing specifically at the time with the war crimes of the Japanese, or alleged war crimes of the Japanese. But it was said nonetheless. The Charter, the United Nations has adopted resolutions, General Assembly has, saying that nuclear weapons are violations of international law. Unfortunately, the United States didn't vote on that resolution. In fact, the only parties who did not vote in favor of that resolution were parties who possessed the nuclear weapons at the time. All nations who didn't, or the majority of those who didn't, did vote in favor of that.
Is the U.S. a party to any international convention declaring nuclear weapons illegal?
Not specifically declaring nuclear weapons illegal, but they have, we are parties to treaties, the Kellogg-Briand Act and others, the Petersburg Convention, the Hague Conventions, but that make weapons of mass destruction illegal and violations of international law, that make weapons that don't discriminate between military targets and civilian targets against international law. Weapons of a poisonous nature came out after World War I that are violations of international law. So no, not specifically dealing with nuclear weapons, but they specifically deal with weapons of the nature of nuclear weapons. Nuclear weapons, by their very nature, are weapons of mass destruction and indiscriminate destruction. In Hiroshima and Nagasaki, everybody was killed. Man, woman, child, hospital patient, doctors, nurses, everybody, not just combatants. If you're going to fight a war, perhaps it's expected that you kill each other's soldiers. But it's not expected that you're going to destroy the entire city, all the manufacturing, all the people in it, men, women, and children indiscriminately. And nuclear weapons do that. And for that reason, they're a clear violation of international law. And in terms of this case, where a person, the principle that came out of Nuremberg was that if a citizen of Germany in World War II had broken into Auschwitz and taken a hammer and beat on the ovens in Auschwitz, he could have raised the principles established at Nuremberg the rightness of his actions, his or her actions, as opposed to the wrongness of the thing that they were trying to destroy. And I think it's a perfect analogy to this case because it's very similar. And the problem is what we're confronted with in this case. Had a German citizen done that, had a German citizen broken into Auschwitz and attempted to destroy the ovens, he would have been taken to a German court, and the German judge would have said, we're not dealing with that. You don't tell me what Auschwitz is about. I don't want to hear it. All we're dealing with in this case is whether you broke and entered. Whether it's a plain and simple question of breaking and entering, destruction of property, criminal conspiracy, criminal coercion. Every charge that's been brought in this case could have been brought against a German citizen who had attempted to destroy the ovens at Auschwitz. And a German judge, applying the law of Germany, would have done just as the judge is doing here and would have given him all the due process in the world. You can cross-examine all the guards at Auschwitz who saw you break in, but tell us why you broke into that place. All we're doing is trying a simple burglary case. And they would put him away. Probably in Germany they would have put him in the ovens, but nonetheless they would have had the same result that's going to achieve in this case, if the judge has his way. He's not going to let them talk about the fact that nuclear weapons are as bad and as serious a violation of international law as the ovens were in Auschwitz. To me, it's that simple. And to me, the American judicial system has to expand its horizons and its vision enough to see that what they're doing is exactly what happened in Nazi Germany. There are differences. I'm sure the rules of procedure and the rules of criminal evidence and whatnot are different, but the effect is basically the same. And we put people in jail at the end of World War II. Industrialists, people who were not in the military complex, who were not military people, but who were just businessmen. And the country told them that we want gas for our ovens, and so they made gas, sold it to the Nazi military folks, and then those industrialists were tried under the principles of Nuremberg, and they said you should have known what was going on. You should have known what that gas was going to be used for, and you should have refused to do it. And because you knew and you didn't refuse to do it, you are criminally liable as an individual who knew what was going on and who refused to do what you could to stop it. And we attached criminal liability to those persons. The defendants in this case know what's going on. They see what's going on. They see that the nuclear weapons are the 1980s or the 1970s Auschwitz ovens, and they're just trying to stop it. And they believe, and I believe, that did they not try to stop it, they could at some point be held liable for violating international law, just as the industrialists were at the end of World War II. And that's basically their position. And they are not asking the court to just let them go. All they want to do is present this evidence to a jury, be able to say to a jury, this is why we did it. This is the principles under which we believe we had the right to do it, and then let the jury decide. If they were wrong and the jury rejects that, then they've had their defense, and that's what Nuremberg provides. It's a defense. It doesn't automatically absolve you, but if you fall within the principles of the Nuremberg decision, then you may be. But it's a jury question, and that's what they want to do. They want to tell the jury why they did what they did, and tell them why nuclear weapons are against international law and crimes against humanity, and let the jury decide. It seems to me that that's the classic purpose for having juries. Juries were intended to be put between the state and jail. If the conscience of the jury dictates that they be released for whatever reason, then they should be. It's a basic democratic principle. And that's, I think, at the bottom of what's going on here.
Thanks very much.